Hello, everyone,
Hi.
and welcome. I'm Antoinette Warren, and I'm the CEO and founder of Warren Publishing Group. And we are celebrating our 9th year of business starting this year, doing successful advocacy. I'd like to thank our co-presenters this evening, Alameda County Care Alliance, and the National Coalition of 100 Black Women San Francisco chapter. We have been presenting valuable information on elder abuse in the months of August, September, and now in October. Our session this evening is titled Financial Abuse versus Estate Planning. This session is going to be recorded, and if you would like a copy, please email RenewMag, R-E-N-E-W mag, with your email address, and you will be sent a copy. And also there'll be a 15-minute Q&A, and you'll be typing in your questions into the chat. And if Georg doesn't get to your question, you can reach him directly, and he will put his number in the chat, and it's also on the flyer that you received. So I'd like to introduce Georg to everyone. He is a good friend of mine, and he has over 35 years financial industry experience and has a holistic one-stop approach to working with small business owners and families from every income level. He holds insurance licenses, life and health and property and casualty in multiple states, and is a nationally registered investment advisor representative. And I'd like to thank you, Georg, for your time today and educating us on the question of elder abuse versus valuable information. Georg, it's all yours.
Thank you. Thank you very much. Before we get started, whoever has the controls, would you allow me to share my screen, please? Is it you or Amy, Antoinette?
Excuse me?
Who has the control?
Okay.
Allow me to share the screen. Ah, very good. Thank you. All right. Thank you for that. Thank you again, Antoinette. We're going to kind of zip right through this. This is a subject that's dear to my heart. I've seen too many people. Before we get started, if you would be so kind, if everyone could mute your microphone so that we can eliminate the background noise. Thank you. This is a subject that's dear to my heart. I've seen so many people just work years throughout their working life and accumulate assets only to watch them be lost through litigation and lack of having a plan, bottom line. And so I'm honored that Antoinette has asked me to present to you guys tonight. It's a short topic, but don't take it lightly. So I've got a PowerPoint prepared that I will be going through. And I'm going to share my screen here. I think Antoinette did a good job of giving you my credentials. If you have any questions about that, please feel free to ask. As Antoinette said, we're going to have a question and answer session here. Let's see here. Hold on, am I sharing? Can you guys see, I'm on the wrong screen first of all, can you see Warren Publishing Group, Financial Elder Abuse?
Yes.
Okay, there we go. I had a little trouble on my end. All right. Hold on 1 second. So, Antoinette, when you were doing the introduction, I thought you were going to say I'm over 35 years old, which would have been true. But I like the sound of that 35-year-old. It's been a while. Anyway, all right. So again, everybody, just thank Warren Publishing Group and Antoinette Warren for this elder financial abuse versus estate planning presentation. Again, my name is Jorrick Gaines. I'm a financial educator and advisor. So let's jump right into it and ask the question. What is elder financial abuse? I'm sure if some of you have attended Antoinette's presentations in the past, you probably know, but I took this right from the Medicare Advantage website. Elder abuse or exploitation as defined in the Older Americans Act of 2006 as the fraudulent or otherwise illegal, unauthorized, or improper act or process of an individual, including a caregiver or fiduciary, that uses the resources of an older individual for monetary or personal benefit, profit or gain, or that results in depriving an older individual of rightful access to or use of benefits, resources, belongings, or assets. In other words, this type of abuse involves taking advantage of an older person for financial gain. And it's rampant out there. I mean, I guess by some standards, I'm considered a senior citizen. I'm now 63. So, and you get all kinds of emails and texts and phone calls. I mean, it is just amazing what people are out there trying to do to just take advantage of people. I got one saying that I think it was my Wells Fargo account was had been compromised and I needed to call them in. And I'm like, I don't have a Wells Fargo account. So that just shows you they're just doing a blast approach and hoping just a few people respond. So moving right along. The topics we're going to discuss tonight is what is probate and why should you avoid it? And I will add like the plague. Who should have a living trust and its benefits? Wills versus trust, advantages and disadvantages, and the benefits of a completed and filed medical directive. Now, the other thing is, and I took this again too from Medicare, how can seniors protect themselves? And I think the topic is that we're going to talk about is at the bottom, but I think the most important one is at the top, and that's remain socially active. Because Antoinette and I have attended seminars, and there's this Guardian video that's going around. And if you haven't seen it, you need to see it. You become inactive and staying in your home and not going anywhere. There are people that think you can no longer take care of yourself and you might have mental problems, and they will come and take you and your assets. So please stay as active. Find something that you love to do outside of the home. I know we're in COVID right now, but that won't last forever. This too shall pass. And stay active. Avoid joint bank accounts. Don't be offended by this, but I don't care how much you trust them. Try to avoid that because money changes people and it makes them make bad decisions. Don't give up your home. I've seen seniors, and I'm also a real estate broker. I don't practice the buying and selling of real estate. I use it mainly for advisory, but don't give up your home. Don't put anybody else on title if you can avoid it, even your kids, because again, it makes them make bad decisions if they start thinking about their personal gain. There are a lot of people that put their kids on title with them saying, oh, I'm going to sell it and I want them to handle it so I don't have to deal with it, so I'm going to put them on title. And there's some other downsides to that. I won't get into that tonight. Invoke a power of attorney. In other words, seek legal advice. And then the last one, the topic of discussion is to set up a revocable trust. Placing a senior's assets in a revocable living trust and naming a fiduciary can be one way to protect asset, protect against outsiders from getting access, well, I'm struggling with that, to any of the seniors' assets that are of significant value. And what's significant value? Well, it's all relative, right? But generally, when it comes to probate, it's over $150,000 in the value of your estate, which I'll cover in just a second. So let's talk about probate for a minute. California probate. And I'm going to read this verbatim. Probate is a legal proceeding that is used to wind up a person's legal and financial affairs after death. And one thing none of us can say is, I'm not going to die. We're all going to pass. So we've got to take care of this. In California, probate proceedings are conducted in Superior Court for the county in which the decedent lived and can take at least, notice, at least 8 months and sometimes as long as several years. Do you need a probate? A California probate is necessary when a decedent dies testate with a will or intestate without a will with a California state value in excess of $150,000. If the decedent had a formal trust, take note, if the decedent had a formal trust, then probate will not be necessary as long as the decedent's assets are held by the trust. That is significant. That's called funding the trust. You have to get your assets in the trust to avoid probate. And I've seen several people set up a trust and not transfer the property in the trust. They pass away and it still has to go through probate. Probate process is costly and time consuming, and that is not an exaggeration. Matter of fact, I'd probably say that's an understatement. The probate process can take anywhere from 6 months to 2 years to complete. The length of the process depends on the size of the estate and whether there are any unusual assets that require special attention. And I would say any unusual, which may not be unusual, litigation. How do I avoid probate? Having a living trust helps you provide for your loved ones, even if you pass away, while also saving your family from the stress and expense of dealing with probate. And those are the two biggest issues. It's expensive, it's stressful. Not only are they dealing with losing you, then they've got to deal with all of the other stuff that comes up. So while having a will is a good idea, and incidentally, a will is included in a trust, but while having a will is a good idea, it is still subject to probate upon your death, while a living trust is not. So we're going to take that living trust and really hopefully get you to understand why you should have one and get you to take some action. That's the most important part. In California, there are several common and effective ways to avoid probate when it comes to passing on property or assets. Estate is less than $150,000. You can have a revocable living trust. You can have a non-revocable living trust. Joint ownership of your property, transfer on death, commonly called a TOD, or a payable on death, a POD. Now, let's talk about the attorneys. And I have several friends that are attorneys that do estate planning, and all of them tell me, well, yeah, a person can spend whatever it costs to get their trust done. But quite honestly, as a lawyer, I prefer they don't have a trust because we get paid more money. That was an honest response. So let's look at the fees. Both the executor and the attorney will be paid per California statutory, I think that word is misspelled, fee schedule below. Attorneys could charge per hour, usually a minimum of $350 per hour if you can find one at that rate, or a flat fee, but most will want to go based on a percentage of the value of the estate. I bet you don't have to guess why, because they make more. You can get an idea of how high these fees are by looking at California statutory, yep, it is spelled wrong, statutory fee schedule. For ordinary services, a lawyer / executor can collect 4% of the first $100,000 of the gross value of the probate estate. I don't want to belabor this, but I just want to say gross value means you could have a house worth $800,000 and owe $800,000 it's based on the value of the estate. It doesn't matter whether you owe anything or not. 3% of the next 100,000, 2% of the next 800,000, 1%, we could probably stop there, but 1% of the next 9 million, very few people have a $9 million estate, 0.5% of the next 15 million, and a reasonable amount of anything over 25 million. So let's see, probate and living trust. Using this system, probating a typical California estate with a gross value of $400,000 would cost $13,000 in legal fees. A very large amount given the amount of legal work involved, which is why attorneys love it. They do their simple process. Those that do it know it by like the back of their hand, and they just go through it and knowing once it's settled, they're going to get paid, which I consider to be an exorbitant amount. The estate would do much better if it paid the lawyer by the hour, but they're not going to do that because it's statutory, which basically means it's mandated by law. So they can charge it and say, hey, that's just the way it is. So this fee chart is a quick breakdown, what I'm about to show you, of the California statutory compensation for attorneys and personal representatives in probate cases for different sizes of estates. It is important to stress that both the attorney and the personal representative are paid under this statute. Thus, if both the attorney and executor elect to receive a fee, the amount paid will be double that I'm going to show you here in a second. Now, let me clarify that. In the case, if you do not have a living trust, and let's say your child is the executor of your estate, either because you chose them to or they were the one picked, they can opt not to be paid. And I got to tell you, it's a lot of work if you have an estate, and especially if you have siblings or relatives that are, taking legal action for their benefit. It can take years. And I think an executor should get paid even if they are related, even if they're the child or whatever the case may be. Their siblings probably won't like it, but that's the way it is. That is statutory. So here's an example. If your estate, well, let's even skip 100,000 because in California, it wouldn't even need to go to probate. But at $200,000, the compensation to the attorney and the personal representative will be $7,000. That's $7,000 each. So the worst case scenario, that's $14,000. But let's get real. If you live in California, especially in the Bay Area, and you own a home, your estate value is at least on the worst case scenario, $500,000, assuming you have nothing but your house. So if you look at $500,000, that's $26,000 that's going to go to the executor, and $13,000 to the executor and $13,000 to the probate attorney. Again, assuming no litigation from other folks. And that's almost unheard of when you don't have a living trust. On a $600,000 estate is $15,000. I'll jump up to $1 million. That's not unheard of here in the Bay Area. On $1 million, that is $46,000 in legal fees and executive fees. So, and then you can see the rest of it. So as you can see, the bottom line, it is very expensive. Now, I want to cover a couple of other things that I see frequently. Being a real estate broker, and I've been licensed in real estate since 1982. Frequently, I have talked with seniors, and I'm not going to I'll let Antoinette talk about the abuse part. I'm going to talk mainly about the estate planning part. But a lot of times, these seniors are being taken advantage of by people that supposedly love them, but they're using their money for their main benefit, which is why you don't want to give them access to your checking and savings accounts and credit cards, because they will use it for their personal benefit. It has happened too many times. But the one thing I see a lot, and I've had people call me and ask me, and they say, well, I don't need to get a living trust. I'm going to put my daughter on the title with me. There are a couple of major problems with that. One, think of this. If your daughter is on title with your property, let's assume it's a 50-50 joint tenants or whatever the case may be, or tenants in common, forgive me. And let me give a disclaimer. I should have did this at the beginning. I am not an attorney. That's one thing I am not. So let me really get that really clear with people. I'm a financial advisor. I've been in real estate since 1982. I've been an advisor in financial businesses the last 25 years. So I've seen a lot over my many years, let's just say. But one of the biggest, again, mistakes that people make is they put the kid on title, and then the kid goes out, gets in a car accident, has California minimal auto insurance. There is a $500,000 claim. The insurance company will only pay $50,000. And guess what the attorneys start doing? They start looking for assets. And because your kid is on title to your property, it is considered their assets, and the attorneys will go after it. They will force it sold. They will do whatever they can to settle that case for their client, because they don't get paid unless their client gets awarded some kind of, judgment. And so that is one of the biggest problems. And of course, I've even heard of cases where kids have gone and down to the bank or a finance company and got a loan on their mom or their grandparents' house without the knowledge of the grandparent, because they are on title. And so be really wary of that. There are some attorney firms, I happen to know one or two, that actually will administer your estate. They will be the fiduciary, and it doesn't have to be a family member. Yes, there is a fee, but it can be a lot less expensive than litigation later on. The other thing, and the other disadvantage of putting a kid on title is, some of you may not be familiar with this, but the taxes when that property is sold is based on what you paid for it versus what you sell it for. If you are the only owner, let's say you've owned it for 40, I got a client, 89 years old, owned her house 52 years, and she paid, I think, $120,000 for it. Now it's worth $900,000. If she puts her kid on title and she passes away, if the kid decides, I don't want the house, I'm going to sell it, they keep the same cost basis of $120,000. So if they sell it, that means everything above $120,000 and capital improvements that they can document, they have to pay capital gains taxes on, simply because the kid was on title. If the kid is not on title and they have it in trust, they get what is called a step up in basis. What happens when that owner dies, the property is appraised, and whatever the value is at that time is now the value today. And if the kid decides to sell it, that could literally be no capital gains taxes due. So there are a couple of disadvantages of putting kids on title. And the biggest one, I think, is it could, have your property be litigated in the event of something going wrong. All right. So get advice. I'm more than happy to talk to you again. I'm not an attorney. We can talk, have a consultation. There's no cost or obligation. If we feel you need an attorney, I have a few that I can recommend. I typically give 2 or 3 names. You call and interview them and see who you want to use. I'm not allowed to, as an investment advisor representative, I'm allowed to just refer a certain person, okay? So let's talk a little about a little estate planning can help avoid these fees. So you can see that a little estate planning during life planning, including the use of a revocable living trust, could save your family a great deal of money and stress down the line. When you think about it, it doesn't take much to have an estate worth a great deal more than $500,000 in the Bay Area, especially here. We're unique. I think only Hawaii and New York and California kind of fall in that category. Everybody else is a different world. But all you need is a house, and it doesn't need to be in the greatest of neighborhoods, and it's worth quite a bit of money. So you should protect that. And, I've heard people say, oh, well, I don't care, I'll be gone. I said, well, look, you didn't work 30, 40 years of your life to give it away to attorneys and the county and the state in taxes and legal fees. So protect your assets. Even if you got to give it to your kids and they do nothing but blow it, that's better than giving it to the attorneys and the county and the state, in my humble opinion. So one other thing, please, 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 especially if you are a senior citizen, have your medical directive, your HIPAA forms done. If you're a Kaiser member, as I am, they ask you to do it and upload it. Because if you don't and you end up in a coma or in emergency, no one can make a decision without a court order, without that document on file. They can't give your medical information to anyone. I'm sure somebody on this call has been through that. So please take care of that, because it alleviates a whole lot of problems and agony. It's enough to be suffering physically. It's another thing to have to suffer financially going through that as well. So Antoinette, anything else you want me to discuss or cover? That's a brief presentation overview, but it's a compelling one, I will say. You're muted, Antoinette. Anything?
Thank you.
You're welcome.
Let's see if there's some questions.
And let me just say, even if you have a question outside of wills and trusts and estate planning, feel free. You know, because there's more to it. There's also, some people may have stock from a previous company they worked for that they never sold. There's just so much we don't think about.
This is Janie Castillo, St. Mary's Center. Is there a guide that you could send us that's real easy, user-friendly, that we could walk through for how to set these things up correctly?
That is a great question. Is it Janie?
Janie.
Janie, we actually work with one company called Legacy Shield. I can send you a brochure. We have, that's a great question. That makes me think of something else, because you have a lot of options. Obviously, the first option is you could do nothing and just let whatever happens happen. But we have a digital solution. If those of you that are okay with completing it on the internet, and it has what they call today, if you're not familiar with the term, artificial intelligence, which basically means as you complete the online application, if you will, it will guide you to the documents that you need. That's the best example of making sure you get it done right. And once you complete it, and I'll be willing to help anybody that does it. Once you complete it, it is reviewed by a staff of attorneys. I'm probably sure it's only one, but there is a staff of attorneys, but somebody reviews it in the legal department to make sure it's done accurately before it's compiled. If it isn't, you'll get an email saying, hey, we need this document, or you didn't do this correctly. But there is a brochure that the company has that can try to just give you the basics, if you will. So that's the digital platform. Just to go through a couple of other options. You could use a paralegal. Beware, they're not attorneys. So if they make mistakes, there is no recourse. Secondly, I do have a couple of attorneys that give my clients a pretty significant discount, about 25%, 20%. And then, of course, you could use your own legal advisor.
This is my last question, sir. Thank you so much. We also work with a lot of seniors that do not have huge assets like this, but they do have precious belongings that they have. And is there some way to make sure that their wishes are taken care of? Because we actually have several circumstances where the family has gone in and taken everything, and everybody's all angry and upset, and they should be mourning the loss of their parent. Instead, they're fighting and bickering and just create these wounds that last for decades. So is there some way to protect our low-income seniors?
Well, the only thing you can do in that case, I think we have a great solution with this company I was mentioning earlier called Legacy Shield, but it may not be for people that are not computer, literate, if you will. The only thing they can do is get a will, have a will compiled, put together, whether they do an online version or, I can't see using an attorney if you don't have assets, because it's extremely expensive in my opinion. Yeah. But they need to do a will. They need to put in writing what their wishes are and who they wish to have what. Now that requires a notary and 2 witnesses, if I remember correctly. Again, I'm not an attorney. So, and I always advise people when they do a will, give it to 3 or 4 people. Don't just take it. Because that's another one. One of the biggest mistakes a lot of people make is they do a living trust or a will and then they put it in they save the deposit box and nobody else has the key but them.
Uh-oh.
Yeah, and that doesn't work. So you've got to give it to 3 or 4 people. You could put it in an envelope, seal it, and say, only open this on my death. You know, and then that way, and then tell the other people, hey, I just want you to know, I gave a copy of my will to 3 or 4 people. So that won't eliminate it, but it'll cut it down. Because the disadvantage of wills is they are contestable. Anybody can sue you over that. So, but that's really the only thing. The other thing I tell people, I'll tell you something I really would recommend. I want you to hear me when I say this. Give it to them while you're alive. Don't wait until you die.
There you go.
Give it to them now. If they're gonna blow it, at least you get to watch them see what they blew it on. Give it to them now. Watch them. Tell them what you want them to do with it and watch them do just the opposite. At least you can say, well, I tried. But seriously, on a serious note, give it to them now. You don't have to wait till you die. You know, you got an heirloom or a ring or some jewelry, you want to give it to your granddaughter, give it to them now. Watch them use it. All right, did I cover that satisfactorily, Jane? Very good, thank you. Any other questions?
Yes. I have a question.
There are questions. If you go to your chat, you will see other questions.
Okay. My chat.
Antoinette, Terry just spoke up.
Go ahead, Terry.
I wanted to ask, is there like an average fee for setting up a living trust or a roundabout fee?
Well, it really boils down to the value of the estate. If you're going to use an attorney, and attorneys don't like me quoting their fees, so you didn't hear this from me. I've had them several times tell me, look, don't be telling people what I charge. But I find on average for basic, what they call an AB trust, if you're married, that's husband and wife, it's somewhere between $2,000, $2,500. Every now and then you'll find an attorney that, and be careful with these advertisements you see, but you probably, to get a decent one and an attorney that has insurance, you know, malpractice insurance, you're probably going to invest a couple grand, $2,000, maybe a little less, probably a little more. Just depending on the attorney.
Okay, thank you.
And go ahead, let's see. I don't know why I can't find my chat window. Let me see.
The other question is, please explain power of attorney for finance, and does the power of attorney for estate cover the health care also?
There are several powers of attorneys. There is a general power of attorney, which basically gives a person the right to do almost anything. It doesn't cover, though, the financial in some cases, because sometimes you might want different people handling different things. So there is a financial power of attorney. And what was the question? Does it cover what now?
Does the power of attorney for the estate cover the health care?
No, that is, well, that's the HIPAA and the medical directive that covers the health care. That's what that document is solely for, only for that. So it's not a power of attorney. They call it I don't know why I always struggle with that term, but the advanced medical directive. Thank you, whoever said that in my mind. And the HIPAA form. The HIPAA form gives the doctors and the surgeons and whatever authorization to talk to someone about your condition and allow you to help them make decisions. So that's separate of a power of attorney. That's financial power of attorneys, general power of attorneys, specific power of attorneys. So I could say, Antoinette, I'm gonna give you power of attorney to sell my house in Oakland. Okay, but you don't have access to anything else. So again, based on your situation, I suggest you talk with a legal advisor.
The reason that I asked that question is in the work that I've been doing for many years, people don't really understand what the differences are, and until you or your loved one gets to the hospital, and then they ask if there is someone that has the power of attorney for healthcare directive, okay, or power of attorney for your estate, at which both are very critical.
That indeed they are.
So for session 2, which is going to be next Wednesday, you're going to be given a demonstration on the ease and simplicity of setting up your personal will and living trust. So can you just go over a few things that be specific in what you're going to cover, so those that are present now will be so encouraged to join us next Wednesday. And if there's any other questions, please feel free to type them in the chat.
Well, with the company that we use to help people that want to save money, that's usually the case, or they feel they're a little tech savvy, because this is a do-it-yourself version, if you will. It's simple, in my opinion. You just have to be committed to doing it. But it is a fill-in-the-blank digital platform. Now, one of the things I really like about it, and somebody kind of mentioned this, it also has a unlimited storage vault. So for all of us that have all of these pictures of family for generations in some cases, and we want to pass it on, you can get with somebody, scan it, and store it in the vault. One of the things that's growing in popularity, and I encourage people, is end-of-life videos. A lot of people are creating videos that they'll speak to people once they're gone and can't talk to them anymore. And all of that is stored in the cloud, in the vault, your personal vault, and there's military security. We'll show. I'm going to probably have to use a video. I've been trying to see if I could get a blank demo, but they're refusing to give it because of the privacy issues. So we may be using a video and maybe showing one I've set up for myself that's pretty vanilla, but I can't go into details of the trust because of privacy issues, and that's a big issue. So especially with our firm. So we will just be talking about how simple it is. It really isn't that difficult. I understand the psychology is that people don't want to deal with it. They don't want to think about their mortality, so they procrastinate. And I'm the same as everybody else, just so you know. But we'll be talking about filling that out and things, more importantly, what to think about. Because there are a lot of things we don't think about what we should do. And, for instance, things we should give to somebody. Sometimes it isn't physical stuff. Sometimes it's my thinking, how I got to where I got to be in business, or what I did to succeed in business. See, our intellectual property is more valuable than money, in my opinion. Because if I leave behind what made me succeed or my values, you can't put a monetary value on that. So that's another way that we can use to kind of leave our legacy behind, if you will. Yes, sir. Mr. Keith, you're muted. Are you muted? Because I can't hear you. I can't hear you, Keith. Keith, are you? Okay.
You have to, there you go.
Okay.
You're unmuted, but we can't
Not
hear
muted,
you.
but we can't hear you. Are you plugged in?
Unplug your, maybe.
Put it in the chat, my brother. That's all I can say.
He can't wait. I'll call him.
Okay.
Let me talk.
Any other questions, concerns?
So
I wanted to say something. I was the power of attorney for my daddy, and financially, and as soon as he died, it completely stopped. And I don't know if people realize that that happens, that as soon as people die, you are no longer the power of attorney, and you no longer can solve any problems after his death. So I thought that would be something to mention.
Very, very good point. A power of attorney is like a contract. And one thing about a power of attorney in any contract, it is void by death of either party.
Mhm.
So if you have that, which is another reason why you should have a trust, a living trust if you have assets, because in the living trust, it names a successor trustee. And as soon as you can provide a death certificate and a copy of the certificate of trust, walk into the bank, financial company, real estate company, then you can proceed as though you were that person.
That was a great point that Janie brought up, because
I'm gonna let you say.
if someone is your power of attorney and you pass away, then the person that would have the last say regarding your burial and your finances would be the person that you're married to.
Oh,
Yeah.
Keith I have Keith on the phone. I'm gonna see if you guys can hear him. Keith, can you say something?
Can you hear me?
Can you guys hear him?
Yep.
Can you
Oh,
go
you can
ahead?
hear me?
Yes.
Okay, hi. Okay. Keith Rivenwine, President of the Council of Elders of St. Mary's. My question is, if you've already filled out your paperwork as far as who's going to be in charge of your situation once you pass, for instance, say like your sister, but then it's not notarized, but you have it sent to 2 and 3 different people. But say you have a son, would he be able to protest that from my sister?
Probably. I mean, it's really just a matter of getting a good attorney. And as they say in law, it's not what's right or what's wrong. It's what you can prove. So, and that's one of the biggest disadvantages of wills. They are contestable. But the more people that have it, but if you don't notarize it, you didn't execute it. So somebody could, well, yeah, it's not executed. You didn't get 2 witnesses and you didn't get it notarized. What's your proof?
Okay.
So
Again, it's not what's right or what's wrong. It's what you can prove.
Right.
okay.
Thank you.
We'll bring that to the organization, that point, so we can help our seniors get theirs notarized. Thank you. Thank you, Keith.
All right.
So I think someone in the chat wanted to know what your fees would be, and I guess that varies. So
I'm not allowed to do technically estate planning. I can direct them to Legacy Shield, and they are backed by attorneys. I can talk with them and help them fill it out if they get stuck, but I'm not allowed to give legal advice. I am not an attorney.
So another question is, what if you have the 2 witnesses but not notarized?
Still, who's to prove it? Who's to say it was actually, who witnessed the signatures? What can you prove?
Mhm.
It's all about what you can prove.
Mhm.
And all the notary says is, before me came these 2 people and signed this document, I'm giving it my stamp. And if you don't have that, then you just have a piece of paper with a couple of names on it. An attorney will rip that apart. I can promise you that.
And definitely in California, you can write your own will, with the pen and paper, but you need to get it notarized.
Some of us have been through this. Somebody's gonna come and say, "Oh no, my brother got it, and my brother had him write that. That wasn't, and that's not what my daddy wanted." Yada yada yada, right? And then there you go. Now I got an attorney. You got an attorney. Our sister got an attorney. And if it's not a big estate, guess how much money we're gonna get?
Mhm.
Not much.
Nope. And then we're gonna be hating each other. I know people said, "Oh yeah," I remember this lady told me once. She said, "Me and my brother haven't talked for 15 years over $3,000."
I believe it.
Wow. So I guess what we can do is, in preparation for our next session, those that want to get more information, and those that already have an idea of what it is that they'd like to put into a will or an estate can come prepared to be able to write that information down. And as Jorg prepares us in his training.
Antoinette, I don't know how I don't know how I did that, but I failed to put my contact info on the presentation. So I put my information here on one of my websites. As you can you see, I see that okay? WealthWave and my phone number.
Well, oh, okay.
And oops, forgive me, the 510 number, that's my cell number. The 408 number goes to my branch office. I'm a part of Transamerica on the investment advisory side, so that'll go there. So don't call that number. Dial the 510-421-1429. Something got my eye.
And so you are available to give information to us and anyone else regarding savings and how to make the money to put into our wills and our estate.
Absolutely, and we won't get on this subject, but I was just on a training today. The other issue we've got to be thinking about is, long-term care and the possibility of being in an assisted living facility. And if you have any assets, you won't have them long if that happens. So we've got to put a plan in place because it is bankrupting people. And of course, if they have to go on Medicare and a state-run facility, then Medicare liens your house if you have a house. And yeah, they'll take care of you and you don't have to pay. But when you die, there's going to be a lien for what you used while you were here. And your family will get the house less than that. Incidentally, you can go to my website at wealthwave.com.
That is so true.
/JORICK, my first name. And at the bottom of my website, let me shrink this down a little bit. If you want to schedule a consultation, if you go down to the bottom, there's a place, where did it go? There it is, schedule an appointment. You actually get access to my calendar and you can schedule a time. I ask that you either call or text me and let me know because I get a lot of emails and sometimes I miss it. But I do look at my calendar several times a day. So feel free to do that. Of course, you can email me or however you choose to contact me as well. Okay.
This was absolutely great information, and I think that we were going to question our participants as to whether they would like more information on investing and insurance, various insurance needs. And if it's something that would be interesting to you, please just put it in the chat. Just put yes. That'd be great.
Yeah, I have a presentation on the different types of life insurance. The one especially for older people, they've got to be under 80. 50 to 80, we can get them life insurance up to $25,000 with no medical required. It's not cheap, I'm gonna tell you that. But I even had one client whose father was diagnosed with stage 4 cancer. We got him covered. It has some stipulations, and I'll explain that to you. So some people think they can't get it. I did have a guy today who was 81, though. I had some health problems and get him covered. So get it early. That's the best message I can give to anybody. Here's the truth, whether we want to believe it or not. Today is the youngest you'll ever be for the rest of your life.
That's a good one.
Sure.
That's a good one.
You will never be any younger after today than today. And life insurance is based on age and health for the most part. But it's also the best way to transfer wealth. It's also the best way to protect your wealth. And it's also the way to not leave your family with a financial burden of putting you to rest as well as paying off your debts. Because believe it or not, if you have the Kenmore refrigerator that you financed when you die, they still want their money.
Yeah.
Definitely.
It doesn't go
How
away.
do they get it if I'm dead? I mean,
They'll
The
let in your estate if you got an estate worth.
oh, I see.
Yes, they will. Which is why when we pass, it has to be why all deaths are published, because their companies have people that do nothing but scan the obituaries and cross-reference it with names to see if any of their people passed away.
Yeah, but the best thing to do is don't die with any deaths.
That is the best thing. The best thing to do is to don't live with any debt.
Don't live with any deaths.
Absolutely, I agree with that 100%. I will say one thing. I always get a little controversy when I say this, and I'm going to end with this. I do believe you should not pay off your mortgage. That's my belief. I can back it up with numbers, though. I can back it up with numbers. So that's the only debt a person should die with.
Okay.
And, you know, reverse mortgages aren't as bad as some people think. I know anyway, that's all I'll say. We are the How Money Works company. We teach people how money works. Don't make decisions based on what your grandparents did. It's not that same world anymore. The world has changed. So educate yourself. Knowledge alone is not power. Knowledge applied is power. Learn and do, because if you learn and don't do, you wasted your time.
I like that.
Thank you. Thank you so much, George.
You're very welcome. Thank you, everybody, for coming. We appreciate it. And everybody, if you're going to come next week, bring one person with you. Just one.
It's Wednesday, October 28th at 6 p.m. Before we close, I'm not sure whether or not one of my co-presenters was on the call yet, but I did acknowledge both of the co-presenters today. One was the Alameda County Care Alliance, and the other was the National Coalition of 100 Black Women, the San Francisco chapter. And I think that,
on there.
Excuse me? I think
Ms.
that,
Hickman is on.
well, that's what I'm getting ready to say. I was gonna thank Maxine Hickman, who is our president. Are you still with us, Maxine?
Yes, I'm still here.
Thank you so much for your support.
You're welcome. Thank you.
Appreciate it very much. Madam President, thank you. And thanks to all of you for coming. And again, if you'd like to have a copy of this presentation today, please email me at renewmag@gmail.com. And session 2, which is next Wednesday, October 28th, is going to be the demonstration on the ease and simplicity of setting up your personal will and living trust. And George, I think you have a closing remark.
I just want to say, where are the guys? What's up? Why is this mainly? I see a couple.
Third Council Member Keith the Ribbonwines here, representing for all of them.
Notice the ladies that take care of us. Much love to all you ladies.
Yeah.
No, there was a gentleman on the call.
Yeah, there was.
Keith is still here. Keith is still here.
Oh,
Keith
okay.
is holding it down.
Yeah.
Oh,
Okay.
Guy Rich. Oh, that's good.
All right.
Thank you very much,
Have a
everyone.
great evening.
Thanks, George.
Have a great evening. All right. Bye-bye now.
Bye-bye.
Bye-bye.